Good morning, everyone. Happy Monday. Jackie Broman here from TBA Law. And look, the tech. When you do a video on your iPhone, it's usually a mirror image, but I've worked out how to flip the video, so now you're seeing the words in the right way behind me. So other than that little win, I hope everyone had a great Easter and a really positive Anzac Day, and we're back to now regularly doing our Monday mornings, short information sessions here. The videos will be posted as well as being live, so if you don't catch it live, that's fine. It's still in our feed in Facebook, and you can tag someone in at any stage if you think it's important information. Now, today I wanted to talk about estate planning for blended families. So there are a lot of complexities for blended families, or there can be. So with estate planning, it's really important to, everyone's circumstances is different. So often when a blended family comes together when children are young, it's not as much of an issue unless children from one partner aren't involved in the new family at all. So let me give you a couple of scenarios. The first scenario, mum and dad remarried. Dad has 2 kids in primary school, mum has 2 kids in primary school, so it instantly becomes a family of 6 and they all live together. Blended family, kids are young, so they're brought up in the household. Very different scenario from second marriage, mum and dad come together, mum has her 2 kids, but dad only gets to see the kids every second fortnight. So it's generally a family of 4 with 2 extra kids coming in every fortnight. So there can be different family dynamics in that scenario. Versus the scenario where mum and dad come together, mum's 2 kids are in their early 20s, dad's 2 kids are in their late to early 30s. The kids never live under the same roof. They never form a parenting relationship with the new spouse of their own parent. And so there can be all sorts of other dynamics in that scenario as well. Sometimes the adult children don't accept the new marriage, and it can cause lots of problems for estate planning for these families. So one of the things that we have to do with the strategy for estate planning is work out what the competing obligations are. So in a previous video, I'd talked about who can make claims on an estate. So obviously children can make claims against your estate, and that includes stepchildren. So in a blended family, the stepchildren of the new spouse can make a claim either on the death of their own parent, if their parent's the first one to die, or on the death of the second with the new spouse. If their parent died first, they can make a claim against their step-parent's will. So we have to weigh these things up. And there's a few different tools, I suppose, we can use with estate planning to try and make sure that we don't have a claim. Firstly, there's superannuation. So I'll mainly focus on the scenario where the 2 parents have come together and formed the second marriage after their kids are adults and have left home, okay? So it's a later marriage, maybe they're in their late 50s, early 60s. The parents want to leave the superannuation that they've accumulated during their lives directly to their kids, but the house and anything that they build up between themselves will be left to each other. So that's a good way of giving the children something first, so they're unlikely to make a claim against the spouse getting the rest. And then they have to wait for the second spouse to die, just like any other family, in which case you would hope that the spouse doesn't write out the stepchildren in the will. So superannuation is one tactic you can use. A trust or a form of life interest, which is a form of trust, can be used as well. So quite often the 2 parties come together, again, later marriage, one has sold their house, the other's kept their house. So they move into a house that's owned by one of them. They never put both names on the house. So the person who owns the house gives the other person a life interest. So they can live there for life. And the kids have to wait until the second person dies before they get anything. So this is a way where you don't really leave anything to each other. You leave everything to your kids on either side of the family, but it's delayed until both have passed away. So that's another way of balancing things out. Or the final way, and this really works well for the families that have been blended for a long time, is that you've got to just have the open conversation and say, look, this is my spouse, I've got to leave everything to her or him. And then you've got to trust the spouse will leave the estate equally to all the children, not just their own children. And there are some tools we can make sure so that they don't breach that trust after the first person passes away. So lots of things to consider for blended families, and there are more and more blended families these days, so it is important to make sure that we think about competing obligations and minimise any chance that there is a claim that a stepchild will jump in and say, no, I want mine now, and put the surviving spouse in a tough situation. So, blended families, if you know of anyone who would get something out of this video, please tag them in. Otherwise, I'm going to leave you to your Monday. I do these Facebook Lives every Monday at 10. Next week is more estate planning, I think, for farming families next week. But we do post a couple of things to let you know what the topic is coming up. So I hope you have a really happy week. My